admitted in the hospital. My father has been admitted in the hospital. Yes. Only 10 days. Only 10.
Accommodation is sought on the ground of uh,
Non-compliance order dated, my lord, 26/7/20.
have you served the notice?
Yes, yes, my lord. So,
Have you
kindly, my
filed
lord,
have you filed your
17.
affidavit? Was there any direction for affidavit?
Yes, we have filed our affidavit.
You have
My lord,
filed?
yes, my lord,
Why you have not complied the order, sir?
my lord, the case of the petitioner was disposed of keeping in view
Where is the
another
direction? Where is the direction?
the direction.
Page.
Page 8, my lord.
Opposite party number 6 in extending the minimum wages benefit under the notification.
But the page 9, your lordship may kindly see the order passed in case of the petitioner. Petitioner case was disposed of in terms of one Vijay Kumar Sahu. And
Yes, my lord.
yes, my lord, but that is what I am explaining, my lord. My lord, SLP was preferred against this case of Vijay Kumar Sahu.
So
SLP
whatever we-
dismissed. SLP,
Whatever, the order remains.
yes,
If the order remains, then whatever is the direction passed in that particular writ petition is the order
Yes,
deemed to
ma'am.
have been passed in this matter.
my lord,
There were a direction under paragraph 16.
yes.
Have you paid all the minimum wages
My lord,
in
so far
terms
as
of
that,
the notifications? Have you calculated the area? Have you paid it with an interest?
well, that is
Tell
what
us.
I am saying, my lord. In case of Vijay Kumar Sahu, the SLP we had preferred was dismissed. Thereafter, we have preferred a review application.
Does it
Which is
mean that there is a stay? Will
No.
you go on like
No,
this?
there is no.
We are issuing a rule that we do not find this explanation to be satisfactory. No, sir. This has been a continuous exercise. We don't appreciate it. And there is a recent judgment which says that mere filing and
Filing.
review that does not amount to the
Right.
stay. Sorry. And we are conscious
Lordship may,
of the review jurisdiction there.
your Lordship may grant us 2 weeks time.
No,
so that
sir.
in between, we will pursue that review and so,
No,
so
sir.
we will
We
take
will
steps
not.
for compliance of the order.
We will not. We are issuing a rule.
Lordship may,
We are issuing a
Lordship may kindly have a glance that we
yes.
have-
We'll
against that Vijay Kumar Sahu case, we have preferred review, my lord. That was dismissed
understand.
for not filing the counter affidavit. Lordship, the Vijay Kumar Sahu case was dismissed in SLP for not filing the counter affidavit. Then we filed a review petition which is pending before the Honorable Apex Court. So
Was it admitted?
No.
Vijay Kumar Sahu.
before Supreme Court.
How can it be your SLP?
Yes, in our SLP, your Lordship may kindly see the SLP order that
SLP was dismissed to 24, my lord. SLP was dismissed in 2024.
Oh, to come to the point. Your SLP, whether what was the issue was issued. First thing is SLP has yes stages.
para 4 of the order, your Lordship may kindly see. Para 4 of the order. Today, when the case is taken up, we could elicit from the government counsel that in fact the state had not filed any counter affidavit in the concerned proceeding, which is under challenge before this court. In view of the circumstances, we see no reason to entertain the matter. The special leave petition is accordingly dismissed. Thereafter, the next page, your Lordship,
No, sir. It was not that it is filed. It is that this SLP does not have any merit. Sorry.
this, the next page, your Lordship, we have read. I have read it. Yes, I have read it. The next page is the review, which is pending. So, Lordship may grant me 3 weeks time, and
No, sir.
I'll take instructions regarding. regarding implementation and to pursue that review
No,
with
sir.
better.
This cannot be given a premium to this. Sir, this order has been passed in 2024. We are now in 2026.
Judgment dated में 23 the judgment date.
14/11/2024, this order was passed. We can't sit eternally for all time to come. Sorry, we can't.
Okay, last chance may be granted.
As a realized issue of a organization matter, the payment of wages notification from 2012, 2009 notification. Authorize also, I mean, you are also too difficult. But paying the minimum wages, is statutory.
What are you talking about, Mr.? That is the irony of the entire, I would say, the modus operandi which is appearing in your office. Every time the new council is engaged and he does not know that what had happened earlier. So on 17/11/2025, Mr. D. Mohanty, who appeared, and he says that please grant me an adjournment so that the instruction regarding the compliance of an order can be made. The matter again appeared on 8th of January. Similarly, you asked for a time. Sir, how long the court will continue giving you all kind of a privileges, the latitudes, the leniency? This cannot happen, sir. This is a high time where we should. Yes. give with that. That's a Friday?
Yes. Some matter also said. So,
What's it? Another
On-
party?
no, yes, my lord, on another petitioner.
Yes, sir, the same fate.
My lord.
Other matter is not assigned by my lord this bench.
Two matters are there, my lord.
It is assigned.
Other-
The other matter has been assigned to this bench.
Those matters are sent to another bench that is also listed today and 15.
25. Yes. Yes, ma'am.
But these
Court
two
number
matters are assigned to this bench.
Yes.
No.
Some matters are 25.
District
Yes.
Court.
Yes, obligation.
Item number 3.
Lord, item number 3.
So if I
Yes.
may please, my lord, before I start the argument, my lord, I would like to bring,
Argument.
my lord, before I start, my lord, what has happened is there are similar 14 matters which are
Why?
today.
Are you interested in pursuing the matter?
Yes.
Don't matter. Forget about what there are other connected matters. The contempt is the individual violation of the order.
Yes,
It's an individual act.
my lords.
It's not a. What is the earlier order?
My lord, this is the
Those are not to this.
my lord, today first time it has been listed.
The matter any earlier order.
My lord, all of them are posted today.
15 February 2025.
My lord, that I have not filed, my lords.
A very casual and cavalier manner of
In other matters of the same, for
we
the,
don't know, this is a special bench. It has to be, we will see to it on the other day.
my lords.
Item 4.
With liberty to mention, what date has to be released. Yes, madam, what is this review?
Your Lordship, I am for the
Oh, yes, you
I
are.
would like to seek an adjournment on behalf of Mr. London. Senior
Sir,
counsel.
You knew it, this bench is very difficult to sit. When the bench is sitting, we expect from the member of the bar, when they are they are being given a notice well in advance, that they will come and do the matter.
Your Lordship, there is a medical emergency.
3 weeks.
Item number 5.
May I please, Your Lordship?
What wrong has been committed?
Lordship, wrong only by relying upon the
Brother, tell us, he is here. To sort for a review.
review petition is filed because only his evidence affidavits para 2 is referred while dismissing the adultery of the wife is not taken into account.
Okay, I can take consent of my previous counsel or engage him, my lord.
You have to secure his presence.
Yes, my lord, I will,
Otherwise, we are not going.
yeah, I will also examine that like or that is applicable to the suppression of material facts.
No, sir. May I read?
That I have
Brother
not,
will read it so
I
loudly.
will go through, my lord.
First 10 sentences are enough.
My-
there in 1997.
Then, my lord, I will ensure that the previous council appears, my lord.
20,000 was the cost.
Then,
We are in 2025.
then I will ensure that
28 years have passed. So 20,000 will increase to
I will ensure that previous council appears.
3 weeks.
I have a copy.
Item number 7.
Your Lordship, in item 7, there has been a bereavement in the family of my learned senior, Mr. Lalit Mishra, Your Lordship.
3 weeks.
Highly obliged, Your Lordship.
Item number 8.
May I please, my lord? My lord, I have filed one memo for withdrawal of the contribution, but I don't want. No, my lord, that has not been complied. But I have been instruction that my client was harassing by the office repeatedly. So he was constant to file one withdrawal memo that if they will comply. But till that they have not.
What is the dichotomy of this submission? I am failed to comprehend.
So I don't want to press the withdrawal memo, my lord, today, my lord.
One time you are putting a aspersion about
Because
upon them, and the second breath you are saying I am withdrawing.
My lord, since 2013, the petition was retired, but she is not getting the pension benefit till yet.
But the order has not been complied with, my lord. Somebody, my lord, the reliance which was placed upon that order has been complied with.
It is your duty to bring this notice.
My lord, he was eagerly.
What is going on, Das? This is the way. If
Unless I understand.
we are not going to authenticate those veracity of those statements, but still once it has come, is a point, is a time when you should introspect. What is this? You can't behave and act in this fashion, provided it is true. Can you ask your client to name a person?
The SAVITRI, who is the
I am asking that when you say that your client has said that somebody they are going and they're pressurizing, harassing, and thus coercing you to withdraw, I just wanted, can you? Sir, why you are asking for a withdrawal with the liberty to file afresh?
because of fact that initially the
Sir, are you aware when the order was passed? What is the date? 19.
My lord, the order was passed by the
Now
state
dismissing the writ petition when it is passed.
to 2023, my lord. Annexure B, my lord.
23.
My lord.
Now you find this in 2024.
24.
Now you are in 2026.
My lord. But they are not
withdrawal
no,
and a further filing an application for contempt. Section 20 of the Contempt of Courts Act, are you aware? Have you applied your mind?
Because the repetition was filed by the state
But I
government.
am asking you, you are not understanding what I mean. Are you aware of Section 20 of the Contempt of Court Act? What? What it says?
Within 1 year?
So, if you withdraw liberty, what will happen? 2023 order.
Not press mail.
Have you read a Pallab Seth judgment of the Supreme Court?
No, my lord.
Please go and read. Justice Rumapal was one of the member of the bench. To prepare Counsel for the petitioner prays for an expedition.
Comply the matter. If there is no order,
Sir, if your earlier statement appears to be true, do you think that they will comply?
Personally, we hope that.
Good. Reveal your, exercise your good office, reveal a good sense.
Item 9.
This review petition is being argued by the senior standing counsel for the comptroller and auditor general. He is out of station while some paying for the short assignment.
3 weeks.
Not that.
As a last chance.
Yes.
Item number 10.
Amended
This
cost
husband-
still not received.
I filed my.
Date of the order has been inadvertently typed as 10/12, 12/12.
I filed the introductory application. It is yet to be allowed, my lord. I filed the amendment petition that is there on record.
Pending.
Yeah, I filed IN number. Yes, I filed.
That has not been allowed.
Not been allowed. My lord, only to change the name of the contaminants because some
I
of
understand.
file.
But that has already been orally allowed, sir.
I filed it. I will make the correction.
What are you doing? It was orally allowed. You were directed to file
All right.
amended.
Still, I filed it. I will make. If my lord permit me, I will correct the names.
3 weeks.
Only names.
3 weeks.
Pardon?
If the registry that they should also act upon your file.
Yes.
File, as you are saying, or might be you
He
have
has
filed.
not filed. He has filed an IA as if it has to be allowed. It has already been allowed. File it.
My
3
lord,
weeks time, just acknowledge.
my lord, along with that order, my lord,
File
my
the
lord have directed them
amended-
to take instruction.
Amended, what is the rate? Cost item. Is intended by 2 weeks from the matter to appear after 3 weeks. File it.
We'll file it by Monday or Tuesday, my lord.
Whatever, sir.
But at the same time, last order, they have to take
It is
instruction.
all connected matters.
All are on one
Same-
judgment. One judgment.
Same order.
Yes, yes, same judgment.
File it.
Item 11.
Item 11, my lord, the judgment dated
Special petition dismissed or allowed.
dismissed in case of others, my lord. Well, Lordship, kindly see the last order. Lordship's order is there.
Last order is
At-
31st October.
My lord.
So SLP against this particular judgment is pending.
It's pending. And relying upon that judgment, that order, my lord, which was at flat C, another case has also been dismissed by the Honorable Apex Court. But in case, since my case is when
So take steps there. Take steps there.
we're taking steps.
What we can
And
do.
my instruction is, my lord,
Anyhow,
yes, sir.
it appears that the special petition filed against the Call the list.
Fresh admission item number 1.
Item 1 minus 1 pass over.
Oh, pass over.
Mr. Misraj,
Sir, this is
they have filed an affidavit stating to have complied the order and want that to be dropped.
That affidavit is there? That is not there, that is in your hand section. What is madam? They have complied. 101 check has been annexed in this affidavit.
Your Lordship, Director
Against the
Assistant
name-
Agriculture Officer will give to the State Bank. That State Bank will forward to the insurance company, agriculture insurance company.
So you have received.
My lord, they have stated that the check has to have been submitted to Fulbani branch. Though it is a Contamala branch,
Now the LP number 1, the bank has filed their respective compliance affidavit.
we have filed the complaint affidavit in the contempt matter. But only that part of the insurance company was to be compliant. So, but they filed the SLP, then the review. In the review, they have filed that. The Lordship will find paragraph 6. Para 6 of this affidavit, today affidavit. Yes.
Check has been issued for 66,000.
Check has been issued to the bank. Now bank in turn will pay back, so the order is fully complied, so the review petition should be dropped. That is their concern.
Now what?
Oh,
What's for the bank?
sorry. The original check is keeping. He is keeping that check.
Oh,
Only
What
showing to
remains?
your Lordship the count.
Not complied.
My lord, the original check minus the
And
favor of the bank.
that has to be, that was issued in the favor of the bank. The
Yeah.
bank has to encash it and then have
Pay
to
to
pay.
the transfer the said amount to the
Correct.
bank.
So,
And the direction was the direction in the REIT appeal that calculation has been made by the agriculture officer and that should be submitted to the bank.
now the money has come.
Yes,
You
ma'am.
are interested in the money or you're interested in something else?
No, I am interested in money. I pray my lord, a stipulated time may be given so that the bank should be.
Sir,
Yes.
everything is here.
Yes,
This can be done in a very short time.
Yes, my lord. That time stipulated may be given. Only I am.
I was stuck up in the traffic jam, your lords.
What? There was no
Traffic jam.
traffic. I think this town.
No, I was there for half an hour, I was stranded.
There is no traffic.
Yes. Your lordship, that check is here, your lordship.
The only thing is that since it's your order, so they will not press this trigger. They have only
I'm handing over, may I be handed?
and record that this is handed.
Check hand.
Yes. Basic.
Covering an amount, give me the details of.
Check.
Record them.
Yes.
Do you have a photocopy?
A photocopy
Yeah,
they have given. They have
along
given
with
in the
that,
affidavit.
That's
They have given in the affidavit.
Take. Yes.
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 Okay. May I play your lordship? The
This
other-
is a
so-
check
so
or
all matters will be.
so this is a draft, a check, not a draft.
No.
Is giving
So-
that original.
So review you do not press. No difficulty. Content we are dropping
Yes.
in view of this.
Yes.
Adherents.
And single judge case that will
And
also.
your Lordship may record that
That may be disposed of.
that check is handed over here.
But why did you not give a draft? Check will again take because this is
No,
a
no,
official check.
no.
It will go to the bank. In one
Got
state
the
bank.
check.
State bank will encash this check issued by them and then correspondingly pay this within 2 weeks.
Because they have the account your lordship in the bank, so that they will have to transfer it back.
Oh, that is
All
what
right,
we are
all right.
saying. It will immediately be.
Yes.
That
No,
is
no. For the order, I want to know this is a account pay check
Check.
or a
Check your order.
draft.
In favor of the bank.
Yes.
In favor of the
Account
bank.
pay check
The
number.
State Bank of India
Full bond.
branch will encash it and thereafter
Within
remit
2
this
weeks.
amount or credit this amount into
Your
our account
Your
or his account.
his account.
His account.
His account.
Yes, within 2 weeks, sir.
Within 2
Within 2 weeks.
Your
Thank you. You got the money.
Yes.
Obliged, madam.
Positive.
Yes.
Yeah.
the contempt will be dropped
Yes, yes,
and the review not pressed.
yes.
And the single child repetition will also become infraction.
Yes.
We'll record that.
Yes.
Great. Accordingly deemed to have been disposed of. Great.
Item number 2.
Last order by 30 January.
Contempt, review, Diraga disposal of request.
Seems rather.
Yes.
Issue of the final relief have been granted, there is no point of keeping this red petition, which is also deemed to have been disposed of.
Order has been complied. Your Lordship.
You got it?
Proposed to be complied but not received, my lord. Proposed to be complied.
What proposed to be complied?
My lord, not
Lordship, may I
deposited.
Oh,
That
it
above-
is to
that-
be cleared within 1 month.
One.
So we are dropping for the time being, the
Yes.
content.
Ah.
And on this
My lord.
assurance, now they cannot. If they do not, then it is a
My lord, your lordship.
Well, everything, fixation and everything has been.
Can we declare as disposed of?
Yes.
Huh?
Yes, sir.
The single bench order is quoted on 26/4/2021.
My lord.
I am not going into the technical part.
Your lordship.
I am not going into the technical part. Whether the content application lies before the division.
My lord, because your lordship. Because
fact,
But I tell you very frankly, my own judgment there
yes.
of a special bench headed by me. If the appeal is dismissed simpliciter affirming the order of the single bench, then in that event, the contempt application does not lie to the division. It will lie before the single bench.
My lord,
Where the order
Here, my
passed
lord-
by the tribunal.
tribunal.
Tribunal
I
has
have
been.
seen the single bench has said this
No,
order is
no
there.
single bench, my lord.
But that,
So it should go to the tribunal.
No,
that
tribunal
no
abolished.
more exists,
Oh,
but
That is
it
why,
is abolished.
then it's
that,
That
just,
had been observed in the last order.
and that is reflected in the last order.
the writ petition assailing the
May I please, Your Lordship?
What
On
is the-
on the last occasion?
What wrong has been committed by my sister?
What I humbly submit.
Oh, you have gone for a review. That
Yes,
means you
because
find error.
my Lord directed last time 97 Supreme Court, but that is
Yes,
not
sir.
applicable to me. Because kindly see the order sheet.
No, no,
The review of the
two things to have the 97 apply in a case. There are two facts which are necessary.
yes,
Whether the advocate in record of the main petition, what is this, writ petition or writ appeal?
writ appeal
Writ appeal. Whether the advocate in record of the writ appeal
is here.
is the advocate in record of the review,
Yes,
is the arguing counsel of the writ appeal, is the arguing counsel of in the review.
yes, that I am explaining, my Lord. Only I will not go
No, no,
into the
please
merit of the
give me
matter.
an answer first, yes or no.
He,
First, give me answer yes or no.
he was
I
unwell.
am asking you, sir, very simple question.
Now he
I
is not
think it is so simple.
there.
Nobody can have
Well,
any explanation.
At least kindly allow me some bit. At least 1 second.
Whether
So I will clarify.
whether the arguing counsel of the writ appeal is the arguing counsel of the review. I
Yes,
think it is very plain and
yes,
simple.
yes.
Yes. No difficulty, then 97 does not apply.
Right.
Mr.
That is
Kanungo,
some development.
Mr. Kanungo, is that correct?
No,
Is the
I
arguing
say-
counsel the same?
No, no, arguing counsel got the matter admitted in the review.
Sir, I expect a very high degree of,
No, if my Lord would
I would say, the
sir,
conduct,
can the
ethical
petitioner be
values
remedialist?
from the bar. I
Can the-
believe
can
that
the-
is the most important facets.
At least my Lord, at
And
least
I am
my
not
Lord can.
groomed, Mr.
can-
Counsel, listen, I am not groomed in an atmosphere where there can be any kind of an incorrect statement to be
No,
made
no,
by
no
the bar.
incorrect statement. Kindly see.
This is,
When the
they owe a greater responsibility to the bench.
okay, I can allow me. At
And
least
we
one. I will
bench
not.
always believe there is statement to be
I
sacrosanct.
will not get into the subject matter unless this is
Mr. Kanungo, one moment. After answering that question correctly, thereafter you make your
Yes,
submission.
yes.
So why are you saying
Today
yes?
the arguing
Yes.
counsel. Today
You
the
said
arguing.
yes. My sister asked you a question. Is it a correct statement made
No,
by
no, no.
you?
I am sorry, the arguing counsel today is not the arguing counsel who was there.
You said yes to me. That yes,
think
who was the arguing counsel is the
No,
arguing
no, I
counsel.
beg
Yeah,
excuse for that.
I think I believe so.
I beg excuse
I
for
think
that.
every member
I beg excuse
understood
for
your
that.
answer, sir.
I beg excuse. Should I proceed, my lord? The
Then why not 97 will come?
that is that how why 97 will not apply? The arguing counsel of the writ appeal has filed the review application, and he got the matter admitted. Notice was sent. Today also he has not disappeared from scene. He is also there, and because he is unwell, that is also reflected in order sheet.
Ask for an adjournment. Let him come and argue.
On that will fair, man.
Yes.
He is unwell.
The
That's the
arguing
reason I
counsel come and argue, sir.
Submit. If he is unwell and he will he is from Delhi, he is from Delhi, he will not appear. Can the petitioner be remedialist? And his associate is there. His associate also is there.
Mr. Kanungo, when you make a submission that he is not in a position to argue, then he will
That I am
review whatever
submitting.
is there. No,
I am
no.
submitting that he is not in a position to argue because he remains unwell and his associate is there.
To ask.
His associate is present before my lord. That is how I came to picture. Otherwise, my lord, I will not take my lord's time. He is from Delhi. He has argued the
May I
matter.
know the name of
KK, his name is KK Patel.
KK?
KK Patel.
KK Patel.
Yes.
May I know his age?
He is, how can I say, what it is, what approximately is?
Live stream.
Item number 1.
Waiting for content, first time it is appearing for fresh admission.
On the last occasion, they had taken a decision that they will disburse the amount.
Disbursement,
No, my lords, the disbursement has not been done, my lords, but steps have been taken towards disbursement, my lords. Benchmark valuation has been called for, my lords, and then a decision will be taken by TCAC.
Now, on the last occasion, you say that the amount has already been determined. Where is the question of benchmark valuation now?
This is the instructions, my lords. I have
Now, that is
received.
the instruction you provided on the last occasion.
that you have taken already a conscious decision in disbursing the amounts of determined.
My lords, I understand. Thereafter, I spoke with the concerned person, my lords.
No,
It-
sir, you are playing with the court. That today itself in the morning I have issued a rule.
My lords,
No request. The request may be a very contempt should not be that.
In the last occasion, your lordship directed to produce the records, my lord. Your lordship.
That order was not uploaded.
No, my lord.
But
It is not
communicated.
dispatched, my lord. There yet the certified copy we have not given.
No, the order was not uploaded.
Yes, ma'am.
It was dispatched later on.
Much after.
Your my lord, the limitation starts from the date of receipt, my lord. There is no two opinion about that. From the date of receipt, and your lordship may kindly see the pink flag, my lord. Is the extract of it?
We will see every page and every line.
Gitanjali Cement.
My lord, when the
We faced that.
my lord,
Gitanjali Cement.
my lord.
That is the manner of recording.
Yes, that's it.
What is SM?
My lord, SM, full for my lord.
In the remarks column.
May I see the record, my lord, so that I can assist you? Summary notices, my lord, has been sent in the same address, which are returned back with endorsement. No such company exists there, my lord. That is pink, flag pink, my lord, I have made. And
Yeah, how he has received that?
in the, so far as the order in original is concerned, this dispatch, the extract of dispatch register I have given, my lord, that is at, that is
This
pink
is
flag.
extract
Is
or the full?
No, my lord, full, that is a book.
I wanted that. Have you find the discrepancy here? The officer does not appears to have been very smart.
No, my lord, it is not exact.
Shows. That shows.
Item number 3.
Lordship, here is.
Tell me where is the order?
Lordship, Annexure 1.
Give me a page number.
It starts from Lordship, that is Annexure 1 start page 38. And Lordship offer page 30. Sorry.
For the person, the whistleblower to call eviction.
Public road, Lordship, that's why, Lordship, that is the only public road. And
Before the state.
What do you have to say?
But the paragraph 24 of the current concern with the directly received for estimation of budget.
And what are you doing? Are you supporting an order or are you? You have not filed an appeal.
I take instruction in this matter. Seek the copy.
Can you require? Put it in the next week.
Orders to stay, Lordship.
You know how to take back the position.
Lordship, grateful, Lordship.
Item number 4.
Why you are not serving him a copy?
Copy served minutes may see the notice page 4.
What?
Copy served minutes, AG copy served.
What do you give when he is asking for a?
I have no problem, let's copy served. That is the only problem. If he wants, I can give an extra copy. But I have served, that cannot be valid. 4 minutes, page 4 of the AG copy served. That's it. My auditor is going that receive pillar that electronically is communicated from the TANDON portal, but he has not served any copy. That was copy is served.
Oh, that is electronically communicated by this court.
Yes. No, no. AG copy served is showing in my system. Let me see the read copy first.
Explain. Actually, let me explain.
Yes.
There is
No,
issue
I
with
know.
us.
I
Lordship got it.
I know.
Let the previous, your Lordship's predecessor, he directed that if the copy is served, filed in the High Court, so it is deemed to be a copy service on the state. And we are facing immense difficulty. Suppose 200 cases are filed, we have to take the printout every day. Therefore,
I have some copy minutes, my pledge book. Let's say that Monday meeting. Monday minutes. I've solved the copy back. I'll do it.
Copy in course of this day.
Yes, I'll solve it immediately. Online service may be allowed, Milords. There, I think my learned friend will agree for online service. So the online service with border mutta.
Item number 5.
So the copy of the petition,
Monday. Next Monday, not this Monday. Coming Monday, next Monday.
Come on this Monday.
Not much on. Yes, I have a clear.
Other side also.
Yes, I'll service. I'm in the day post.
Secure his presence and the.
That but he has. He'll be there.
Persons is not belonging to this car. I hope.
No.
Is not.
Please, Your Lord. But here the issue is very limited. First tender was done, it was cancelled, where the eligibility criteria was fixed at 10 crores, the financial eligibility. Second, because they said second time happened, 2 participants were there. Still the eligibility criteria was 10 crores. L1 was another party and I became L2. Then they cancelled it because the first person he could not submit all the required their documents and everything. That was cancelled and I should have been L1. But they again cancelled it and then enhanced the eligibility criteria in the third round to 50 crores. And your lordships on the first occasion asked them to file the counter. They have filed. We have filed the rejoinder. I'll just take your lordships to one paragraph what they have stated and the CVC guidelines of their counter affidavit.
Practically a hearing matter.
Yes, madam.
So why he just what
Okay.
amendment has been
No, already the work order has been issued. So the new notice has to go on the after the if the amendment is allowed, my lord. I'm sorry. Two IAs have been filed.
Where
One
are
for
those IJs?
yes.
Which flag?
Flag. Lord, one is 14503 and 10502.
Where is the other side?
Union of India.
Yes,
Union of India.
The hotel manager managed by the Union of India.
College of Hotel
Then
Management.
why the second application?
Second is the additional parts because the
Contract has been granted.
in favor of one Ganapati.
Mrs. Ganapati Intelligence Services. So that is why the second amendment.
One is additional parties.
One.
Because the contract is awarded in favor of pendency of the dispute.
We do not make any allegations against him.
Lord,
Yes,
personal allegation against the agency I can't make, of course, because we are only confined to the eligibility criteria. And so far as the addition of parties also, your lordship.
Both the applications.
Yeah, both the.
Yes.
And then the notice has to be issued to the newly added, if your lordship.
The question is also directed to.
No, my lord, let me just explain what is now quite disturbing to the entire. My lord, there is a concept called judicial discipline and propriety. My lord, we know that latest patent appeal is a statutory appeal. We are filing, for some reason or other, the matter is not being taken up. But the contempt court, my lord, your lordship knows is a settled principle of law, cannot pass any additional direction in a contempt proceeding. It's well settled, my lord. Contempt court cannot go on issuing directions.
So beyond
Yes, lordship is a plethora of judgments. Plethora of, I'll cite 3, 4 at least the leading one. Midnapur society case I will cite and another.
Very old judgment.
That's correct. My lord, the discipline demands that if the higher forum or the appellate forum is in session over the matter, and despite the fact being brought to the notice of the contempt court, still they proceed and harass the officers every day. You come and be present under the pain of contempt. My lord, a judgment, this particular case, my lord, for which I came, it has huge ramification, not less than 10,000 crore for the pensionary benefit. OMC is a state-owned PSU. My lord, there is no provision of pension. It has not yet been finalized. They are already covered under the CPF. Your lordship knows after 1st January. Yes, employee share and employer share. CPF. GPF. Yes. So therefore, 1st January 2005, your lordship knows there is no pension under the new pension scheme. So it is to be adhered to. Now the court, my lord, original Reed court, directed that you reconsider one aspect. There is no mandamus. And the court clearly observes that pension being a welfare measure and there being no pension scheme so far on being approved by the government, possibly the court was conscious of that fact and did not pass any order. Will your lordship look at the last, the directive portion? There is no mandamus. But still the contempt court now proceeds and says that no, this was what we intended. This was what played in our mind. You can't go on passing additional directions in a contempt proceeding. So this particular writ appeal, my lord, becomes redundant. LPA procedure, it's a statutory appeal, latest patent appeal. So not that we are seeking claim. So therefore, no, your lordship kindly see that's correct. No, stay means under the pain of for some reason we go on mentioning writ appeal is not taken up. Number one. It is on the board. We filed a memo before the court stating that it is already being mentioned before the Honorable Chief Justice. It may be taken up, but the additional Chief Secretary, my lord, has been directed twice to appear personally. You remain present to implement the order. My lord, your lordship may kindly look at page 347.
Which order is at the challenge?
My lord, the contempt order.
Where is the date and which
Millard, your lordship may kindly see every day. This is what page?
which page?
Page, Millard. Two orders, Millard, are challenged. In the writ appeal, first read the single judge order, Honorable Single Judges writ petition order. And the present, the item number, sub-item number, WA 2107, Millard, the last one. That is diary number. That is against the contempt order. Your lordship may kindly turn to page 376. Can the contempt court clarify it? This is what I intended. 376. I'll take your lordship to the original order there. This after this. The court, my lord, last 10th line. The court is not inclined to accept the above contention.
Yes. It is reach.
376 para 3. Direction was for reconsideration. Government considered it and rejected. Yes.
I have not been able to reach at least.
Oh my God, I am sorry, my lord. Sorry. My lord, Justice Raman must have reached because technology. My lord, I also belong to my lord Chief Justice's school. I feel comfortable in. Huh? Oh, you have come. Lord, main case may be hard on merit. Writ appeal any day convenient to my learned friends that can be taken up. But contempt court, my lord, your lordship may stay hence.
Yes.
Yes. The court is not inclined to accept the above contention. Lordship got it. Let me read the whole paragraph 3. Mr. Das,
Let me read that.
Yes.
Yes.
So, my lord, the court, your lordship may kindly look at the order, single judge order. At page, only the operative portion I am showing you. The 4 paragraphs also before that.
Page,
my lord, 347, your lordship may kindly, long paragraphs, 26, 28 and 29. 3 paragraphs I will show to your lordship. My lord, let me just tell the fact. OMC is a state-owned PSU.
Subject.
Yes.
Say that is a completely owned by the state government.
Right.
So the employees are there.
There.
No pension scheme.
Right.
There is no pension rules.
Right.
Nothing on that kind.
Absolutely correct.
Talk of some.
Right. Right.
But it has not been ratified.
Absolutely correct, my lord. Yes.
So now whether the right on the basis of such
communications, deliberations,
whether it has ripened into an inchoate or an absolute vested right.
I am so grateful. That is the essence.
That is what.
That is exactly, my lord. No, your lordship. I was to plead, my lord, your lordship of already. My lord, yes. So the last paragraph. My lord, that has been discussed. And court is conscious that I can't issue a mandamus. But still then, my lord, hauls the officers up in the contempt proceeding. Last paragraph. Court says it is not a fundamental right. Obviously not. It's as a welfare measure under the DPSC, pension, etc., old age, etc. So it is neither a fundamental right nor any enforceable right has accrued in their favor. There is no enforceable right. There may be deliberations, discussions, 3 paragraphs. Paragraph 26. The court is well aware of the limitations prescribed when there is no law in place or any legislation in force introduced either by the legislature or the executive in exercise of delegated authority to make legislation. The High Court is not to issue any such writ. In order to issue a writ of mandamus, there must be a legal right with the party aggrieved, insisting upon the due performance by the authority on account of statutory duty cast upon it. But at the same time, one has to make out a distinction in a case where a direction may be issued to consider a particular provision, like the present one, for a pension scheme asked for by the employees of an organization, a PSU, keeping in view the demand, necessity, and the need having regard to the attendant circumstances around. It may be an order or a direction instead of a writ of mandamus issued by the court, paving the way for the state government to explore and examine all such possibilities to have a provision of pension in respect of the employees of a PSU. In the instant case, the corporation is a gold category PSU and has been on a successful run for quite some time and unquestionably has profitable returns and taking into account the draft scheme proposed, it would not be inappropriate or unjustified to issue a direction to the state government to invent and be experimental to have such a beneficial pension provision for its retired employees. Then law will change. The whole concept of law. This court is fully cognizant of the fact petitioners and other employees retired in the
You have omitted one sentence thereafter.
pension. It is not to be equated with issuance of writ of mandamus by the court. So, Millard, what else? Direction can be issued. I am conscious of it. But can a direction, Millard, otherwise be issued to formulate a scheme and grant the pension by a PSU? If the government is not, Millard, they are already in enjoyment of a particular scheme, CPF scheme. Millard, I am coming one by one. Your Lordship may now kindly turn to PS Millard. They say that one OHPC is giving, so therefore you also give. How can it say body corporate separate? The court is to reiterate view, Millard. Para 28 Millard. OMC with a changed plea at present can be said to have responded in an outlandish manner, peculiarly extending support in backing the state government, more so when it has been the creator and has become the destroyer with a clear intention to abandon the scheme it had once conceived and proposed. Once Millard, they said in 1891, there are lots of correspondences because the public enterprise department is the nodal department, steel and mines, under the rules of business, finance is the department. So it was in a, Millard, so to say, in a nascent stage of discussion. But they come to the court, court says that you reconsider. In one round they came, court did not entertain, directed it to consider. Again, Millard, the directive, Millard, essential Millard operative portion of the order, para 32. In the result, this is what is to be seen. Read petition stands allowed as a logical sequitur. Page 356, para 32. 29 Millard, I was showing you, Lordship, that has correlation with this. Court is conscious that a comparison, etc., we cannot do this, but still then, they said, set aside the decision with a direction to reconsider the extension of the pension scheme for the retired employees of the OMC, duly approved by the state government, with the concurrence of the finance. Way back in 1991, they say finance. Now the government does not want it. It has been rejected by a reasoned order. If the parties are aggrieved, they can go and assail it. But Millard, the contempt court says that this is not what we intended. At page, your Lordship would look at the impugned order 376. Page 376, I may request my lords to turn to that page, paragraph 3. This court is not inclined to, in fact, the direction in so and so 2014 was not only to consider Mr. Vance.
Lord, in fact, I am appearing for the federation, my lord. Lord, what I humbly submit, my lord. My lord,
He's come.
Yeah.
To
well, the copy.
some proposition of law.
Yes.
We are not on your right or
Correct.
what.
Yes.
We are not going into.
Yes.
Yes.
What is the jurisdiction exercised by a court under the contempt of court?
Right.
My lord, I'm coming to
Four
that.
judgments.
I'm coming straight to you, my lord, to that. Lord, lot has been said that a writ of mandamus has not been issued. So that is why the contempt court, in fact, could not have sat over the matter. The fact remains, my lord, in the year 1991, well, only 3-4 sentences, my lord.
Sir, I will take you to that only 4 sentences of the paragraph 32.
Well, I'm conscious.
Paragraph 32.
Yes.
What was the direction which was passed by the court?
Well, that is, I'm exact.
What to be said to be a contemptuous act?
Well, I'm exactly coming to that, my lord.
Please come.
Well, first is in the year 1991.
There was a scheme.
There was
it got a sanction or approval from a finance department. We have seen.
Well, first of all, it was approved by the board of directors by the money corporation.
I appreciate everything.
Yes.
We are, again I'm saying, we are not against an order or in a writ appeal against the original order.
Yes.
We are concerned about the contempt jurisdiction exercised by the
Well,
court.
let me come to that straight away, Malak.
Now, what was the direction
let me come.
Which can be said to have been willfully and deliberately violated by the court, by the
Milad, what was directed by this honorable court?
Yes, in the give him a copy. Last 32. Read loudly, slowly.
Yes.
My reading may be wrong. Please correct.
In the result,
yes,
the writ petitions stand allowed.
True.
As a logical sequitur.
Correct.
The impugned decision dated 28th April 2000
is set aside.
Correct, set aside. And with a direction to reconsider the extension.
What is the direction is?
To reconsider.
Well, what reconsider?
Reconsideration of the extension of the pension scheme of the retired employees of OMC. Duly approved by the state government.
Correct.
With concurrence of the finance department. At the earliest, preferably within a period of 8 weeks.
1991. But don't skip.
Right.
1991.
Exactly, Malak.
So what is the direction? The direction is to reconsider what issue? The extension of this pensionary benefit in terms of that particular approval or a concurrence of the state granted in the year 1991.
Well, I am obliged. Yes.
When the direction is to reconsider what can be implemented under the contempt of court jurisdiction.
Well, I am going to the very root pillar now.
You know the law. I'm saying then what the contempt court will do. Contempt court will not only punish if there is a contemptuous act which is willful and deliberate, but also to ensure the due implementation of the direction.
Well, now, yes,
I'm conscious. What could be the due implementation?
Well, here
the due implementation is that you have to reconsider. Means you have to arrive at the decision whether you are going to extend the pensionary benefit in terms of 1991, which has come, or you are not going to accept it.
Absolutely.
This is what a decision has to come.
Yes.
Otherwise, the word reconsideration has no meaning at all.
Well, I'm coming to that.
Secondly, now, if you say that you have to look into the different other observations which are made to logically deduce that what was actually a direction,
yes,
then in that event, contempt does not. If the order is capable of multiple interpretations,
right.
If one has been adopted by a party, no contempt.
Well, what has been done, Malak?
I can give you a Supreme Court
Well,
judgment which is binding on all of us.
No, Milad, in fact, law is so clear about it, Milad. I don't stand in between, Milad. Well, what
So they can be compelled to take a decision
well, I'm
and communicate their decision that what they
little factual scenario is required, Milad. I will just play only 3-4 minutes of lordship, Milad. Not more than that. Milad, this is the third round of writ appeals before this honorable court. Initially, Milad, the writ application was allowed with a similar direction to reconsider. Well, that came up in writ appeal. The intra appellate court remanded for reconsideration. Again, writ application allowed. Writ appeal filed. Writ appeal again remanded because a particular set of documents were not considered by the writ court. On the second remand, the writ court again allows to reconsideration. Yes, your lordship has rightly put that question to me. What is the reconsideration in the peculiar facts of this particular case? Lordship knows when a company is incorporated, whether a private company or a public company or a state-owned company, it becomes a
just 1 second of reminding. Whatever you are arguing may be a very valid point for the purpose of considering the main WA against this order.
Once
we are taking up this contempt matter, you should know that what is the law on the subject.
Well, I'm coming. Let me come to straight way, Malad.
Three judgments to support your argument. Three judgments.
I understand. I know. I have reminded him.
Correct.
Even my judgment is also staring at his face.
I know that. Well, the thing is that during the when the contempt was filed, a show cause was filed before the contempt court that the order of this honorable court has been complied.
What was filed?
Before the contempt court, when the notice was issued, a show cause was filed that it has been replied. Yes, that it has been complied.
Because they have taken a consideration.
No, what they have done is they have made a total U-turn. The 1991 board resolution.
They have taken a
and yes, subsequent approval by. Well, that is what the honorable single judge had never.
Let me last.
No, what I'm saying, it is in fact the very same judge who had heard the matter and who disposed of the application. It is before the very same judge, and what was the tenor of the order, what was the tenor of the argument, everything are in the book.
It will very interesting argument. Then my counter to you is
yes,
an author of a book and author of a judgment.
Yes,
is the best person to interpret what he meant.
Yes,
but when a book is read by a third party who does not have any knowledge that what has been passing through the mind of an author when he uses a particular word, if he interprets those words in his own manner, which he understood from his knowledge, does it take the man to a conscious?
But I am conscious of
that is why everything will come. You cannot say that what I meant if those cannot be expressed or can be taken to be an express words from the language, the words, or the expressions used therein. If it cannot be deciphered, then how the content lies? I am not against the legality of the order. I'm saying I am not. I have not. Legality of the order, I have not touched at all.
But what
I am simply concentrating on a content jurisdiction.
Well, I am not, in fact,
straight away. I am not saying anything on that.
If para 32 is read in isolation,
what is the meaning? As a man having a judicial experience, if I read it, the impression which is created in me is that the court has not really come up a positive way to say anything. The court has left this discretion to the authorities to consider whether you want to implement this order of 1991 or this scheme of 1991. That means that this particular leverage was given to him. They may come, yes, we are going to implement, notice is no difficulty. They may come, say that we are not going to. Why they cannot go if there is a valid legally enforceable right into you?
Well, that is what.
And in that event, it will.
Well, let me say the one sentence, Well, if I have understood the 5 writs under the Constitution, a writ of mandamus lies when there is a right of somebody, and to put it across, there is a corresponding responsibility on somebody else. So I'm saying
the writ of certiorari.
Well,
It was not a mandamus.
so that is a writ of mandamus which the advocate will says.
Using
Honorable
mandamus does not change
No,
the
well,
fact that you were assailing an order of the government.
first of all, certiorari quashing that order.
So
Then mandamus directing you do. The constitutional court can give a direction to act in a particular manner. It has to be done.
we'll just go to the contempt, and we are happy. So far as contempt is concerned, I think that this order cannot stand in the way.
Well, now the writ application. If
Yeah, we will apply our mind so far as the merit of the order is concerned in a regularly.
Right.
But contempt order, sorry.
Well, now, Lordship, just one more thing, Malad. The writ appeals, have been filed. Writ appeal is filed against both the orders together. The order passed in the writ application.
So this appeal is against only the contempt order.
I think it was writ petition and contempt. Both the orders are challenged to one.
No.
There are 3 petitions because there are 3 petitioners. That is the reason 3 appeals.
We are on 2107 of 2026. That is against the contempt.
I'm on. That is against the contempt order.
Right.
So,
let me
that is against the contempt order.
Which one? What the judge is different.
Last.
What the prayer is different. When I say petition of prayer,
petition, right?
Say jota place করছো jota place করছো ঠিক prayer করছো.
Oh, have patience.
Sorry.
What kind of things are happening here?
Yes.
If I go with the preamble of your writ appeal, I think none of the orders you have left, which is a subject matter of challenge here.
Yes.
No, that is separate writ appeal is there, Mila.
Prayer at page 41.
I am looking at this defective one.
Yes.
Page 3. The preamble of the appeal.
No, your lordship is correct. Well, I got the point. Your lordship is correct. This should be the only this order, impugned order, contempt. Let the page 376 order. Annexure.
Point.
Yes.
Whether 2 independent orders can be challenged in one appeal.
That's correct. No.
Mr. Das, fine. 2 independent orders can be challenged in one appeal.
Separate appeals have been filed. Total Miller.
So I am going by the preamble. Tell me, the order passed in a writ is an independent order. The order passed in a contempt is an independent.
Right, Miller. Your lordship is correct.
Tell me.
Miller, this is an appeal challenging the order dated 12/12/2025 in contempt in the matter of at page your lordship can kindly see 205 etc.
This is the preamble will be like this.
No, that is not correct. That is Miller. At the top also it is written out of order dated 12/12/2025 in contempt case number so and so in WPC number so and so disposed upon.
This is very interesting. Yes. It is a very interesting thing.
Yes.
Writ appeals are filed in the nature of an application.
Writ appeal has to be in the shape of memorandum of. No, your lordship is correct.
What is this happening here?
No, your lordship is correct. Your lordship may also devise how this is not in the rule also. So everybody is filing it like a writ petition. It should be a memorandum of copy. It's a LPA.
Every appeal.
No, your lordship is correct. Right.
In the memorandum, in the form of a memorandum.
Like first appeal or second appeal.
Whatever. It's
right.
A memorandum and then the
memorandum.
application is supported.
No, lordship is absolutely correct. But this prayer, you set aside the order dated 12 passed in contempt case number so and so, whereby the Honorable Contempt Court has construed the common judgment so and so, declare the Milord, 3 judgments I have given. Milord, it is there, supporting exactly the view which your lordship expressed.
Just see
Same-
page 41, my lord. Page 41 of the writ appeal.
All, Milord, incidentally, 2
prayers.
honorable judges are from this honorable court, Justice G.B. Patnaik and Justice Arijit Prasad. 2 judgments.
Otherwise, my lord, in fact, it has come for orders for delay condonation. Today it has come for delay condonation in filing of the
Last
all
5 days delay.
all the 3 tables, my lord. It has
5
come
days,
today.
5 days delay. Contempt 5 days delay.
Contempt. Is it delay?
5 days delay.
There is a defect pointed out by the ballot office, by the registry regarding maintainability.
Defect regarding maintainability that is covered by Midnapur Cooperative Society. Recent judgment. Yes.
Where is the noting of the
I am passing on a judgment to Mr. Das also, Midnapur People's Cooperative, directly answered on maintainability.
That's the only
It's a
ground.
Supreme Court judgment.
There is no delay.
There is no delay.
But as far as contempt
Regarding
part is concerned, my
maintainability.
lord,
Contempt appeal.
independently, my lord, of course there is no delay.
There is no
But
delay.
when both the things are taken up together, because writ appeal has been filed challenging both.
We are not concerned. We will simply concern with the contest. That's all.
Second. Incidentally, 2 Supreme Court judgments. One is authored by Justice G.B. Patnaik, other is by Justice Arijit Prasad from this court. And the first, that one, no, Abhishek Singhvi is also from UP. The same issue. Not,
What you said?
not Manu Singh, Abhishek Singh, I think. Abhishek Kumar Singh, yes, not Manu Singh. He recently.
Record in order in other writ appeal, except the effective one. That the federation was a petitioner there.
Red petitioner was.
In one of the cases. Here, Milord, these 4 persons have filed the contempt. Private opposite party.
There are many writ petitions.
Yes.
3
So that is why 3
common order.
that is why 3 writ appeals. The 3 sets of petitioners, my lord.
Let me understand.
W 180. That is federation.
183. Let me first start.
One 183 is Milord Federation is the
Yes,
petition.
yes, sir.
Yes.
So you are representing the federation.
Yes, sir.
So record his name. That is the director.